Hi, welcome back to my channel Surbi Darya 77. Friends, in the previous video we learnt about the judicial system in India, and today we are going to discuss about the legal terminology as well as how to become a good legal and court reporter. A court reporter must understand the judicial process from the beginning till the end. So the legal reporting requires a physical presence in the courtroom. It is very important to listen to the arguments of lawyers on both the sides, for and against. Observations of judges and questions put by him to the lawyers are very useful for reporting a particular case. A court reporter, my dear friends, should have knowledge of different stages of civil or criminal proceedings. And you should also know where an appeal can lie from the court that you are reporting. First and foremost, I would like to give you some general tips for court reporting. 1. You need to make a background check of each case. 2. You should note the name of the courts along with the judges and the bench in your diary and make a note of all the victims and witnesses that you know of. Always be present in the court and follow the proceedings. 3. 4. Cross-check all the facts with the lawyers of both the sides. 5. Bulk of judgments come from High Court and Supreme Court. So try and be there and note the important points. That too verbatim. Do not tape record proceedings because it is not, permitted. 6. Quote from judges and lawyers are very, very important, but don't blindly accept what the lawyer says about any particular case, because a lawyer represents, one party. So you have to cross-check it from both the lawyers, from both the parties. Don't take sides, be neutral. 7. 8. Do not depend on any news agencies to rewrite your stories. Whatever you have written will not be tampered. 9. Don't resort to media trials in any of the criminal cases. 10. Do not indulge in any sort of contempt of court. So these are the basic 10 tips that I have given. Apart from these tips, let us discuss what is required to be a good legal reporter. Friends, you have to understand your purpose and understand your audience. You have to ask yourself, why are you writing and what you are writing? What are you hoping to accomplish? What is the outcome that you wish to achieve? This will help you determine your tone, your style, your level to details to include in your writing. But you cannot write anything on your own. You have to write the proceedings of the court itself. So good legal reporting requires researching a lot. You can also incorporate relevant legal precedents. Go back to old cases, read what was the judgment in that case and cite it here as well in case it is related. So before you start writing, thoroughly read all the related material of the case. You have to read it to understand the legal issues and the cognizant, that are cognizant of the, applicable jurisdiction. You have to create an outline, a good outline. You have to detail the topic. You have to write the lead, putting the most important information at the top, the inverted pyramid format. Then flush out all the main points with all the supporting details that you have, while making sure that the transitions between the point, they make sense and your writing is coherent, it is consistent. And when you write a legal and a report, or report court matters, try and write in active voice. The subject did something, rather than something was done to them. For example, Rama consulted with her lawyer. It's an example of active voice. Whereas the lawyer was consulted by Rama is an example of passive voice. So you have to use an active voice while writing your legal reports. You also have to avoid the double negatives. For example, this is not the best way to write, or you cannot not communicate. And the Oxford comma, the comma and. So when listing items like judges, like magistrates and clients, you can use it. So use adverbs and adjectives sparingly. Clearly, this is an exaggerated thing if you keep on using the adjectives. Your writing should be consistent, it should be coherent, it should be clear, it should be concise. And use the tenses consistently. Like past tense is the most commonly used, but sometimes present tense makes the most sense. So you have to see that the tenses are consistent. You have to avoid split infinitives as well, like gently push versus push gently. You have to avoid the gender specific terminology. So when you are in doubt, you can use they, because that is universal. You don't have to use any slang or a hyperbole. You have to be very, very accurate and very, very specific. For example, use a specific date instead of saying recently. So this was about writing. Let's come to the news sources now. If you have to become a good legal reporter, you have to establish and maintain contacts and sources of information, which is a must. Court masters or court clerks who maintain the docket, that's the list of the cases to be heard by the judge every morning or every day, is a very good source of information for a legal reporter. And as I said in my previous video where I explained understanding judicial system, I talked about the websites called Live Law or Bar and Bench. They're also a must read now. So tweets from lawyers about a court decision are also very important. Keep an eye on the tweets of some famous lawyers, or the lawyers who are attached to that particular case, for or against. One should always know background of each case to understand the court proceedings, and in the High Court and Supreme Court, all judgments are uploaded in the court website the same day, but it can run into hundreds of pages. So your presence in the court when the operative portion of a judgment is read out, it makes things very easy for you as compared to reading 100 pages on the website. So in case you are reporting arrest or custody of any high profile personalities or any celebrities, you have to be a non-partisan, a very, very objective and very unbiased reporter. So these were tips on the news sources. Now, if you think you will become a good legal reporter without knowing the jargons, you are mistaken. Let us now dive deep in the details. Let us begin with the terminology or the glossary or the jargons, the technical jargons for the legal reporting, as it's very, very important if you want to become a court reporter. So in criminal matters, the reporter must understand the difference, between interim orders or stay, or what is a sentence, What is the meaning of custody or bail or anticipatory bail or acquittal? But the most important thing that he or she should understand is, first of all, what is sub judice matter? What is sub judice? It means that a particular case or matter is under trial or being considered by a judge or any court, and the final adjudication is still pending. So unless the court puts any restraint on case-to-case basis, there is no legal bar on writing or debating about that pending case. But remember, it should not result in directly or indirectly influencing the administration of justice or the case itself or any judge or any lawyer. Now, let me explain you a few important terms which are a must learn for a legal reporter. What is a suit? So a civil case filed in the court is defined as suit. Money or property or land disputes, which are taken to the court, they are called as civil cases. The sub-court or the district or additional district courts, they exercise jurisdiction in the civil cases. The state government fixes pecuniary jurisdiction for each court, that is the monetary value. And the document filed in the civil courts is called as suit. You must also know who is a plaintiff, who is a defendant, who is a respondent, what is a decree, what is a judgment. So the person who files the suit is called as plaintiff. The person against whom relief is sought is known as defendant. The final judgment in the civil court is called a decree. And in criminal courts, accused files a petition and he becomes a petitioner. So state or prosecution is known as a respondent. Final judgment is pronounced by the court concerned after conclusion of arguments of all the parties in that case. So it will contain the summary of arguments of the petitioners, of the respondents, of the state, if that is a party, and reasons given by judge for arriving at the conclusion. So it is essential for a journalist to know the procedure from beginning till the end, as I said in the beginning. How a case is lodged, who is the plaintiff, who is the respondent, or who is the defendant, what decree was passed, what were the arguments made that culminated in the final judgment. Another important term that I want to discuss here is public interest litigation, that's PIL. The concept of PIL evolved by the Supreme Court is very unique, and the PIL can be filed in High Court or directly in the Supreme Court by any organization or a social activist for any public cause in the public interest. Several NGOs have filed petitions in Supreme Court challenging, say, farm laws. So there are many petitions which are filed, many PILs filed in Supreme Court and High Court in the public interest. The next term that the legal reporter should know, I think all of you must be knowing this, that is FIR, the First Information Report. So once the crime is committed, the local police lodges the FIR. So FIR will mention the names of the complainant, the nature of the offense which is committed, the persons who are cited as accused, or date and time and place of the crime. And after the arrest is made, the accused is produced before the magistrate within 24 hours with a remand report. Now, what is a remand report? I'll just be explaining. So every town in the country has a magistrate court with jurisdiction to send the accused to the jail for the offense that he or she, has allegedly committed. And all of us know what is an arrest, the first stage after an offense is committed. So the police has the power to arrest a person, on registration of any FIR. And FIR is the basis of investigation for collection of all the facts or evidences, to record the statements of witnesses, leading to filing of charge sheets and commencement of trial. So at the conclusion of trial, court may acquit or may convict the accused. So what is a remand report? In the magistrate court, a public prosecutor represents the police, and every accused will have a lawyer of his choice to defend him. Now the prosecution submits the remand report, which will spell out the summary of offense under the Indian Penal Code and other applicable laws. But there is a difference between sending to jail and imprisonment. So if the magistrate accepts the FIR, he will remand the accused to jail, initially for 15 days or so, which is also known as judicial custody. So magistrates can also grant police custody of accused for interrogation and to uncover information about the crime. And the initial remand is defined as sending a person to jail. So you must read the Indian Penal Code for this. And I am also trying to read various books on the Indian Penal Code. So after the investigation and arrest of any accused, it becomes mandatory for the police to file the charge sheet or the final report about the incident within 90 days, giving details of offense that was committed and evidence available against each of the accused. Once that charge sheet is filed, stage is set for commencement of trial, which will culminate in conviction or acquittal of accused. So on conviction, the court awards imprisonment for a specified tenure depending on the nature of the offense. There are several terms that a legal reporter should understand. For example, bail and anticipatory bail. What is the basic difference between a bail and an anticipatory bail? So in cases of murder, rape, or say heinous offenses, magistrate takes cognizance of the charge sheet and remits the case to Sessions Court for conducting the trial. The court releasing an accused temporarily pending completion of trial is defined as granting bail to the accused. Now under Code of Criminal Procedures, that is CRPC, Court of Sessions and High Court, it has power to grant the anticipatory bail as well. Anticipatory bail is granted even before the arrest. If anticipatory bail is granted, accused cannot be arrested. So while granting anticipatory bail, court will take into consideration violations of personal liberty in the events of arrest, and also harm can be done to his or her reputation. So as per the CRPC, district sessions, additional session judges of any district can award a life imprisonment or a death sentence to any accused in a murder case. So once the accused is convicted, he or she becomes a convict. Now, for example, somebody snatches my gold chain and he's produced before a magistrate who has the power to release him on bail or on certain conditions if his defense is acceptable to the court. So police registers an FIR against the person who snatched my chain, and A seeks anticipatory bail in the event of arrest. So the magistrate has power to grant him the anticipatory bail if he feels that the person's apprehension is bona fide and real and the police version for arrest is not convincing, and he may be convicted or acquitted after the trial. Now friends, these were the major terms that a legal reporter must know. There are several other terms which are important for you to know. So one by one, I will be telling you about these terms also. Ab initio means from the beginning. Adjournment application means, request for more time for finding the witnesses or important evidences or for other reasons. All of us have heard about the word affidavit, the sworn statement by the litigant in writing. As I discussed appellate courts, so what is an appeal? A lower court decision challenged in the higher court is an appeal. What is an attachment order? The court's authorization to take and hold a person's property is called as an attachment order. Then, who is an attorney general? We've already discussed it. The legal officer who represents the union government, and solicitor general is one who assists the attorney general. Autopsy, examination of a dead body to find the cause of death. We also call it as postmortem. Then what is a bail bond? The security amount usually furnished to guarantee the appearance of an accused person in the court is called as a bail bond. What is a charge sheet? We just discussed that documents in which the police records details the crime against the suspect is called as a charge sheet. Now, if there is a change of place of trial, it's called as change of venue, which is very common. And the case number means the identification number with type of case or date or month or year. There's another word which is called as certiorari. The writ from superior to inferior court requiring the records to be sent to the former for the review. Then we have a term called commutation. Reduction of sentence is called as commutation. What is a concurrent sentence? Imprisonment to be served by the accused at the same time is called as a concurrent sentence. A consent decree. The court order to which the defendant has consented is called as the consent decree. And there's another term which is called as decree nisi. So the final judgment to take effect sometime in the future is called as decree nisi. Double jeopardy. Plea that the defendant has already been tried for the same offense. Defamation. We will also be talking about defamation and the libel and slander in a separate video. But making a statement orally or in writing which can damage the other person's reputation is called as defamation. What is extradition? The process of returning, a prisoner from one country to another is called as extradition. Habeas corpus, the judicial procedure requiring production of a detained person in court to inquire into the legality of the detention is habeas corpus. What is injunction? An order by the court requiring someone to do or not to do something. Then the court seeking reply to the petition is called as issuing a notice. Litigant is the party to make a plea in the court. Another important term is mandamus. So the court's command to an inferior court or ordering a person to perform a public or a statutory duty is mandamus. There's another term which is called as mens rea. So the criminal intention to commit that crime is called as mens rea. Pardon, all of us know, action of, executing, relieving criminal from the sentence is pardoning. Parole, the release of on promise of reappearance at a regular interval or on call, is parole. Plaintiff is the party who initiates litigation or a lawsuit, as we've already discussed this. What do you understand by proceedings in a camera? Proceedings held in a camera are the proceedings held privately, not in public. You're not allowed to take your cameras inside the courtroom. Proceedings suo motu means proceedings launched by the court on its own. One who presents the petition in the court of law is the petitioner. Prima facie means on the face of it. Yeah, what it appears on the face of it. Reprieve means the delay in execution of a sentence. And then we've already discussed who is a defendant, who is a respondent, against whom the petition is filed or an appeal has, been taken. So the stay order, the court preventing an action, is called as a stay order. What is ultra vires? It's beyond one's powers. And writ petition. Writ is direction issued by the court, and writ petition is seeking such directions. Remember, legal reporters, court reporters, you are not an investigator, not a prosecutor, not a judge. You are not a police officer. You are a legal reporter, and you cannot tarnish anybody's image and reputation. So media trials should not be the order of the day. And I hope the terminology and the tips discussed today are useful for you. For many such videos on specialized reporting, journalism, media, mass communication, media houses in India, kindly like and subscribe my channel, Surbhi Daya 77. Thank you so much.